All right, it's up to the interview portion of the program, and we want to welcome somebody who I've come to have great respect for and who I'm really proud to have as my first guest here on the program. He's currently Deputy Solicitor at 8th Circuit Solicitor's Office here in Lawrence. He's also a major in the South Carolina State Guard. He's been an adjunct professor at the University of South Carolina. He was department head for criminal justice at Greenville Tech. He's been a visiting professor at Clemson University and has been a career criminal prosecutor, also spending some time in the 13th Circuit, which I think is Greenville, Pickens, and so forth. Welcome to the program, Warren Mowry. Warren, how you doing, sir?
I'm doing great, Scott. I hope you are.
I am. And listen, thank you so much for taking time out of your busy day to come and be a part of the show. It's the very first interview we're doing for this new show, and so I'm glad to have somebody of your caliber to be present to help me through
Scott,
this thing.
Anything.
I appreciate that. Before we get into the thing, though, I also, and I didn't mention it in your bio there, but you also do some acting, which I think is awesome because, in my other life, I do a little so-called acting as well. So you and I are kindred spirits, as it were.
Yeah, I got bitten by the theater bug when I was in high school, and it is unfortunately been contagious the rest of my life.
That's great. I saw in one of your write-ups, you actually did a version or interpretation of the Few Good Men.
Yes.
And which role did you play?
I played Colonel Jessup, the Jack Nicholson role.
Great. So goddamn right I did.
That's the one. I got to say, you can't handle the truth.
That's awesome.
Every night.
Boy, you know what? Fun. And I saw that movie again just recently, and that line still it just resonates to your soul when he pops off.
That whole speech, even if you don't like Jack Nicholson's character, you have to respect the military because it's just like the police. You want them on the wall. You need them on the wall.
Absolutely. Yeah.
And it's just a matter of how you conduct yourself while you're on the wall.
Absolutely. Excellent point. Well, let's talk a little bit about your before you got into law. What was it about the law that attracted you to it, and what has it always been something that was sort of your passion, so to speak?
Well, it is. I was a history major, but my whole family has got teachers in it. My grandfather was a country school teacher way up in the mountains in North Carolina. My mother was a teacher. My sister's a college professor. I've got two other cousins that are college professors. So, we've got teaching just running in the blood.
Sure.
And history it just always fascinated me, and law is so much of a part of our history.
Sure.
That just seemed like a natural extension of what I was interested in when I was a kid. It just stayed with me. My father always told me when I was younger I was going to be either a doctor or a lawyer. He wanted me to do something professional. And since I couldn't stand the sight of other people's blood very much, my own didn't bother me, but other people's blood I didn't care for that very much. I said, well, that probably lets medicine out. Mm-hmm. So I stuck with the law on that, and glad I did.
Yeah, well, we are too. Was it something that early on you knew was kind of a thing you wanted to get into, or was you more just kind of going to feel it out as you went along?
I wasn't sure. Frankly, when I started in law school, I wasn't even sure. I didn't have a real marketable major, a double major in European history and theater. That doesn't exactly jump out at people when you're trying to market yourself.
Sure.
And I don't know if law school was kind of a way of delaying the inevitable, having to go find something to do. But it was a good experience. I enjoyed that part. I enjoyed law school. I'm glad I did it.
Yeah.
It has been a really good profession, but I did not think I was going to get it in criminal prosecution. Somebody suggested that to me when I was a third-year student, that I might want to consider that. And I said, man, I don't know about putting people in jail. Matter of fact, my first job when I got out of law school was as a judicial clerk. I worked for a judge in Florence, and we were doing probation revocations right before Christmas. Mm-hmm. And the judge, everybody that came up in front of him, if he found out they violated their probation, he would send them to prison.
Yeah.
And it was right before Christmas.
Scrooge.
I was just torn out of the frame about these folks. Oh, this is terrible. And he told me something that stuck with me. He said, look, they had a chance to stay straight.
Right.
Just be an honest, law-abiding citizen.
Sure.
They didn't do that. Yeah. They committed a crime. They got another break.
Right.
So they had a second chance when the judge gave them probation. All they've got to do is live like normal law-abiding citizens do every day. They couldn't do that. I wasn't going to give them a third chance. I said, okay, I understand now.
Which still applies to this day.
Yes,
to
it
current
does.
events in some,
Yes, it does.
instances. That's excellent advice early on. Warren, let's come up to date here in what you currently do. Tell a little bit what exactly it is a solicitor does.
Solicitor is what other states call a district attorney.
Right.
We are the state's attorney. We're the prosecutors. If someone is accused of a criminal act, the prosecutor is responsible for presenting that case in court for, determining whether or not the case should be brought to court.
Right.
A lot of people think that we try to convict everybody that comes up in front of us. That is not the case. I always say that the prosecutor always tries to find out what the truth is. The defense attorney is going to zealously represent their client no matter what. The prosecutor is going to convict the guilty, but try to make sure that the innocent, if they're wrongfully charged with a crime, go free. So that is our purpose, and that is the way it's been established in the United States since our founding.
And you're basically what happens once us as police officers or law
Yes.
enforcement make cases, those cases are handed to you.
Right.
And you take it from there. When you're handed a case or a case file, what's the very first thing when you receive that case? Let's just say a murder, for instance.
Yep.
When you look at that and you say, all right, this is what I need and this is where we're going to go forward to prosecute this thing.
When you've been doing a job in a specific jurisdiction for a number of years, you get to know all of the players.
Sure.
You get to know the defendants.
Right.
You also get to know the police officers. I always say about people that are involved in criminal activity in one way or another, there are three roles. You can either be the victim, you can be the defendant, or you can be a witness. And one thing that I learned is the roles from one case to the next may change, but the faces always remain the same.
Sure,
somebody might be a defendant in one case, a victim in the next, and a witness in the third.
Right.
But as far as that's concerned, beyond that, the very first thing I will look at is, and I don't mean to be insulting to anybody, but I will look and see who made the case.
Right.
There are certain officers that have a reputation of making an excellent case. You are one of them. So if I see that it's made by an officer like you, certain other officers in other agencies, I say, okay, this is going to be a well put together case. There might be some people that if they made a case, I'll realize I'm going to need to look for things that might be missing in it and flesh it out some.
Give us some examples of something that might be missing.
If there is a reference for photographs and photographs aren't in the file, we have learned rather quickly to go ahead and make sure that the photographs are reserved before they get lost in the black hole of the electronic systems. Statements from individuals. If there are witnesses that made a statement, we want to make sure, was it in writing? Is there a search involved? Did you get consent? Was there some kind of exception to the warrant requirement? Or did you, in fact, go get a warrant?
Yeah.
Where is the warrant?
Sure.
What did you find as a result of that? If there are, example, if it's drugs, has it been sent off to State Law Enforcement Division for analysis? Right. All those various things that we have to consider very first thing.
I think one of the things that stood out in my mind during the case that you and I worked together specific, which was happened to be a murder.
Yes, it did.
One of the things that you said, and it was just a simple one-off comment that you made, but it resonated and it was true. And what you're saying here is I think goes back to that is document.
Yes.
Document.
Gosh, yes.
Yeah.
One thing I learned early on is that defense attorneys love to find holes in the case. That's one of the things that prosecutors do is if we've got the right guy, if we're convinced that we've got the right guy, we're going to look at the quality of the case. And if there are holes, we're going to try to find ways to plug. But law enforcement can definitely save us a whole slew of trouble if they will write stuff down.
Yeah.
If there are witnesses, give us the list of witnesses.
Yeah.
It is really frustrating to get into a case and then find out, oh, we've got more evidence. Well, you don't have it in the report.
Yeah.
The problem that you've got is defense attorneys are going to be looking for those holes. And if you don't document it at the time, then you get on the witness stand and you start talking about this other evidence and they're going to say, okay, show me where that is in your report.
Yeah.
And if you're not able to do it, they're going to make you look not so good in front of the jury. One of the things that I tell officers is we've got a very small margin for error. We've got to prove cases beyond a reasonable doubt. You know, if you want to quantify it, let's say it's 95%. I'm 95% certain as a juror this person's guilty. If I am, that means I can convict him. That's beyond a reasonable doubt. So it's a real small margin. And if we start giving away our margin on things that we could have prevented, by the time it comes to decision making for the jury, they might say, you know, all of this stuff begins to add up. I'm just not sure. And they can easily come back not guilty if we're not careful. So law enforcement does itself a favor when they document everything that went on and document all the facts. Do it now, you know, like that old Fram oil filter commercial. You can pay me now or pay me later. Do the work now or you are going to pay later.
And I learned a lot of lessons in those, just sitting in that week on our case particularly.
And you made a good case too.
But even so, and I appreciate you saying that, but even so, there were some things that I wish I'd, you know, darn it, why didn't I think? My next question being, you know, obviously we want to get convictions. I mean, but we are, as law enforcement, we're all human, and as officers, sometimes we put a lot of hours, you know, in at the crime scene and on working that paperwork, doing the things that need to be done. And invariably, there are going to be things that we miss or wish we had done differently as those investigations on scene are fluid, and you know, you're running here to there. Especially when on that one in particular,
and frankly, that's the picture we've got to paint for the jury too. It's that you're trying to paint or make a perfect case, defense attorney, and life just doesn't give us that option.
And I think and I remember vividly during the time of the investigation Chris and I were working on, Chris Martin, who works with me, we were constantly just moving, and there were some things that we missed.
And y'all were up like 24 straight hours.
Yeah, we were just, you know, pounding that thing, trying to hammer everything down, and there was a lot of moving parts. You know, what are some things that you suggest that all officers do once we arrive on the scene? And I'm talking from, you know, first responder to investigators to SLED or whoever it may be, to preserve that integrity of that scene and to make sure we do make as few mistakes as possible as we continue that investigation to its end.
One of the things, if you've got a major crime, Lawrence County unfortunately does not have a dedicated crime scene unit. Greenville County, some of the other big counties do. That is a real luxury for them to be able to call out, you know, immediately, have on hand somebody who is trained in crime scene investigation, collection of evidence, preservation of evidence, all those various things. When y'all have to do it, or when y'all have to call out SLED, you know it's going to be an hour and a half before SLED can get there. They do a great job, no doubt about it. But they're based in Columbia. It's just going to take time to get them here. The main thing is preserve the crime scene, keep the integrity as much as possible, preserve the people that go in and out of the crime scene. I will tell you this happened in Greenville. We had a guy that had been a linebacker for the Dallas Cowboys. He ended up coming back to Greenville, had played a couple of years for Dallas, ended up becoming addicted to cocaine, became an enforcer for a kingpin over in Spartanburg. Well, ended up, we believe, killing prostitutes, several of them. So he ended up becoming a serial killer. He ended up bludgeoning a guy to death with a softball bat, a metal softball bat. It was a purely circumstantial case, but the victim was found face down about a quarter mile from the Greenville County Law Enforcement Center. There was an all-night club there, a private club just down the hill, and the victim was found in the back. The crown of his head was gone. I mean, it literally, his skull was just shattered. And his brain was sticking out.
Exposed.
Yes. And on either side of the victim, by the time crime scene got there were shoe prints. There was identical shoe prints. So it looked as if the assailant had stood astride the victim and pounded him with the baseball bat. We took 2 days getting plaster casts and everything and going with the investigation about the shoe prints. Turned out that they were made by a police officer that had absolutely nothing to do with the with the investigation that just showed up
Oh, wow.
on scene and stood astride the victim looking down at him. So
Wow.
that just really messed us up.
Yeah.
But keep the integrity as clear as possible. Document the people that come in and out so that there's never any question, and allow the professionals to do their work. Keep as few people inside a crime scene as possible. 20 years ago with the O.J. Simpson case, more than 20 years ago now, you saw the videotapes of all these people milling about inside the crime scene, and you just knew it was going to be a cluster.
Yeah.
Just going to be ridiculous. And it turned out to be just
Absolutely that, yeah.
Keep it as simple as possible. Keep it as clean as possible, and it pays dividends later on.
And it's interesting you say that, because it is human nature to want to go, oh my God, let's go look at that.
Yes.
And investigators come after the road patrol.
Sure.
And nothing, that's they show up first respond. And we show up usually after the fact. And it is interesting sometimes that even seasoned law enforcement officers, at some point you have to say, hey man, come back over here. We got to rope this off and do what we do as professionals, like you said. But it is interesting to see guys get really interested in things such as you mentioned, when it is something like that you don't see every day. Well, obviously you're going to, human nature is to run over and look.
And I've learned that from painful experience too, because I went with a homicide investigator in Greenville to a crime scene one time. I have since learned to keep back and keep my hands in my pockets.
Yes.
It was a shooting in a little store, and the victim was shot 3 times. The victim had been taken out as we were getting there. He was dead on arrival at the hospital, but the investigation began, and I stood up against the wall like I should. And then I looked under the lip of the counter, and I looked and I saw this glint of a shell casing. And I said, oh, and I reached down and I said, oh, looks like we're looking for a .32 automatic. And the investigator just looked at me. I mean, he's a friend of mine.
Yeah.
And he looked at me and he just shook his head, and I said, yeah, and I bet we won't find any fingerprints on it but yours. And I said, golly. Luckily, that didn't make the case, but that was a painful learning experience.
Yeah, it's one of those self-correcting errors.
Yes, I haven't made that one again.
That's exactly. One of the things that you and I have spoken about in the past is the training or lack thereof as it relates to courtroom etiquette and testimony.
Yeah.
Police officers are trained in basic law enforcement at the academy in driving, firearms, defensive tactics, taser weapons, all this stuff, CDVs and legals, and we get continuing training throughout the years after we graduate in those different things. But yet we get very little, if any, training on actual courtroom stuff.
Right.
And why do you think this is the way that it is? And what's your ideas on how we can train as officers to better get understanding of how to testify and what's expected of us once we come into court on day one of, let's just say, Sammy Joe's murder trial?
And it's funny, you talk to some officers that have been on the job for 10 years and they've never testified in court. Yeah. That's one of the things that has become acute in the last couple of years. When Solicitor Stumbo came in, one of his goals that he has achieved, I might say, is to try cases. And he himself, in 2 years, in the 4 counties that he serves, has probably done 20. I asked him a couple of weeks ago, and he said about 20 trials in 2 years, which is phenomenal.
It is.
We just didn't do very many trials before that, so people never had much of an opportunity to testify.
Right.
We're trying cases on a much more regular basis now. People are getting much more of an opportunity to testify.
Right.
One of the things that I try to do beforehand, if somebody's unsure of himself, normally we do it with victims or civilian witnesses, is bring them into court, acclimatize them to the atmosphere in court. Sit them on the witness stand. Let them see what it feels like. Tell them, for example, where I'm going to be standing to ask the questions. Direct them. Give them tips on how to speak to the jury. Yeah. Sometimes it surprises me that we need to do it with law enforcement as well. Yeah. Law enforcement sometimes will come to us and say, can you help me out with this? I'm going to have to be testifying in a couple of weeks. What do you want me to do? Yeah. I will actually walk through the questions with officers. I've done that with officers that have made the request. We have come up with things to expect on cross-examination. Yeah. by the defense attorney. So those are the kinds of things that we can do. We have discussed, hadn't gotten beyond that stage unfortunately, but creating a mock trial where officers would get the chance to testify. We would have other attorneys that from our office that would act as defense attorneys.
Yeah.
And so they would get the idea of the grilling of cross-examination.
Right.
That's a bizarre experience.
Yeah.
I've lived in a courtroom since I started, and it's been well over 30 years now. And most of the time, I'm on the giving end of questions.
Sure.
Every once in a while, I will have to testify in a court proceeding. Normally, it is what is called post-conviction relief, where the defense attorney is generally being accused by his former client, who may well be in prison now, of ineffective assistance of counsel. Now, I'm on the witness stand just to tell what the defense attorney did during the course of the trial and leading up to the trial, all the work that he did as far as I was concerned. Ain't nothing aimed at me. I don't really have that much of a dog in the fight, so I'm not going to get beaten up on the witness stand, and I still get butterfly every time I get on the witness stand.
Sure.
So it's just the nature of the beast. So anyway, the point is that it's understandable that officers are going to be a little unsure of themselves the first time or two out. They just need to communicate that with the prosecutor. If the prosecutor doesn't offer the kinds of things that I've just talked about, the officer needs to request a little preparation going into the
and there's no shame in that.
No, absolutely none.
Yeah, I would, in fact, it would encourage it.
Yes,
in some instances.
Now, I will also tell you, I've never put a witness on the stand without consulting with that witness beforehand.
Sure.
Find out exactly what that witness is going to say. Go over the questions with the witness.
Yeah.
Make sure that we're all reading off the same page.
Yeah, right.
I don't like surprises in the courtroom, so I want to make sure that I know what's going to be coming. That's the perfect opportunity for an officer to say, "Hey, can we go a little further than what we're going here?"
Yeah.
This is my first experience with it. I want to do this right. There is not a prosecutor that I know, certainly not in our office, that is not going to help that guy out, because we're all on the same team.
Same team, absolutely. It was interesting during, and I hate to keep referring that back to our trial. But
no problem.
What you and I work most closely on.
I don't mind talking about that one at all.
It was interesting to me, and I sit from gavel to gavel as you did. It was interesting to me to watch when the SLED officers would come down and testify. Yep. And you can tell that they're very well trained in testifying.
Yeah.
And we are taught at the academy on the basic level to address the jury when you speak. Mm-hmm. But to me, it almost seemed that the agents from SLED would overemphasize that point, and at some points would even turn from the defense attorney and face the jury to answer he's standing here, to the left or to the right, and they're facing the jury, not even looking at him. Is that really an effective tactic to sit and face the jury when you're answering?
What I try to do, and the way our courtroom is constructed, where we're sitting in it right now, as you and I are talking, it lends itself to this. What I tend to do when I'm doing a direct examination of one of our witnesses, I'll stand at the end of the jury box.
Yeah.
And it's the officer or civilian witness, that isn't going to make any difference, is going to be looking right at me. And what I tell the witness is, you speak so I can hear you. And that would mean that every one of the jurors is going to be able to hear what that witness is saying. SLED really emphasizes, I would tell the witnesses to refer to the jurors every now and again, just to look over at them and make eye contact with them or something like that. SLED will sometimes, some of the agents will make an exaggerated turn.
Yeah.
I don't mean to say it's comical or anything, but it's certainly noticeable.
It is. Yeah, it is not very noticeable.
But they are very good at what they do.
Yeah. Do you think juries respond to that though? Do you think jurors feel as though you're talking to me, and does it lend more credibility? What's the psychology behind that?
I think what you're doing is developing a rapport with the jurors, and that probably does go a little bit to. We all want to be liked, and there have been cases where jurors have told us, I just didn't like the defense attorney. So there are times when it's not that the defendant's not guilty. I mean, he was guilty.
Sure.
But it didn't hurt the jurors' decision-making, their willingness to convict, that they didn't like the defense attorney at all. So you want, as a prosecutor, you want the jury to like is probably not the right word. You want them to respect you and, like the way that you do things. I'll put it that way. But you want to also develop a rapport. If you're a witness, you want to develop a rapport with the jury so that they are going to be sympathetic to what you're saying. Yeah. And so that does make a difference.
And I think it does. I noticed that, and I would watch the SLED agents and the jury, and I would watch how they would kind of interact. And I don't want to use the word uncomfortable, but in some cases, I guess people are just personalities. Some of the jurors you could see got a little bit antsy and would even look away, avert the gaze, as it were. And that's why I asked, is it as effective as they would have us believe at the academy that you've got to do this when you're on the stand? It just makes you look more believable, or like
more professional.
Sure.
Yeah. And there is something to that.
Yeah.
I will tell you in opening statements or closing argument, I don't stand in one place. I tend to prowl. Pacing is probably not the right word. It's not just a nervous tick or anything. There is a purpose to what I'm doing. But I will try to make eye contact with every single juror.
Yeah.
If it looks like his attention's wandering, I'll look at him a little bit longer until he re-engages. But there is something to that. Jurors, because of TV and movies, they expect fireworks.
Right.
They don't.
Fiery.
Yeah. They're not going to get that most of the time. So we have to disabuse them of that notion. But they also expect a little bit of engagement from the parties, and that's just a way of keeping them in the loop, so to speak.
And I like the idea of making eye contact with everybody and moving on. The defense attorney in my case was trying to make some point, and I don't know what the point was at the time, but it was like he was almost challenging me.
Yeah.
So my attention, I felt like, should have been on this guy.
And I tend to agree with you on that. I mean, that's not, when you're having that kind of exchange, you keep your eye on the person that you're dealing with.
Right.
If you are relating a story,
then
you tell it to the people that need to make the decision, based on what you tell them.
That's an excellent point.
But I know exactly what you're referring to. You handled that, and I don't mean to sound like I'm blowing smoke or anything. You handled that about as well as it could be. You did not buckle under. You were courteous, but you were very firm
sure.
at the same time.
Yeah.
You never lost your cool, and I've seen some police officers do that.
Yeah.
It blows your credibility when you do that.
And that was leading into my next thing here. And I've seen some officers, something stuck in my head, something I saw years ago in some training, whatever it was. And it was another just simple off-the-cuff line was, don't take it personally.
Exactly.
And I've seen some guys take stuff really, really personally on the stand. And I get it, because you're saying I'm a bad cop. How do you avert that? I mean, how do you, as, again, human nature, how do you not take certain things personally when they are attacking you when you've done the best that you feel like you've done?
Yeah, and I've seen defense attorneys beat up on police. They almost make a sport out of it. That's what I'm talking about, maintaining your credibility. The old line about the best revenge is a job well done.
Yeah.
The best revenge on a defense attorney that's doing that to you is for the jury to come back guilty.
Yeah.
Frankly, if the police officer maintains his credibility, if the jurors respect him, if it sounds like he knew what he was doing, if it sounds like he did his job well, and he is just there to report the facts, not a dog in this fight, so to speak, then the jury is probably going to hold it against the defense attorney.
Yeah.
Unless the officer literally got caught in a lie, I think defense attorneys make a big mistake about personalizing coming down personally on a law enforcement officer, calling him a liar, calling him incompetent, unless they have something, a smoking gun, unless they have something really, really hard.
Right.
They probably do themselves a good deal more harm than good by taking that tactic. If a jury comes back guilty in a case like that, and that's been the tactic that the defense attorney used, tell him, didn't work, did it, buddy?
Yeah. Right.
Just suck it up and go on.
Right.
It's very difficult. We can joke about it afterwards,
sure,
but it's got to sting. I completely understand what you're talking about.
Absolutely.
You don't want to be called unethical or criminal or incompetent. Yes.
Yeah. Very personally.
Yes.
Especially when you've dedicated your life to this thing.
Yes.
Warren, give me an example of an absolute quote unquote no-no when you're testifying and when you're on the stand?
Lack of preparation. This is what I was talking about earlier with making sure that you know what to expect. There's nothing worse than a police officer being asked a question, given an answer, and then the defense attorney comes up with the police officer's own report and say, really, that's your answer? Well, didn't you write right here something just to the opposite?
That's when the officer is going to lose some credibility. And again, that margin is going to shrink.
Right.
So that's the big thing is preparation. Thomas Edison was asked how he made all his inventions. He said 2% inspiration, 98% perspiration. I prepare myself so that if I have a major league brain cramp during the course of the trial, if I just completely go blank, then I've got my script, so to speak, written out, that I know the questions that I want from each individual witness, what evidence that I want to admit through or have identified with each witness. I can go blank, but I've still got something I can rely on. Police officers need to be very familiar with their own reports.
Yes.
Especially if they are the chief investigator. Yeah. They need to be familiar with every single aspect of the case. Yeah. And frankly, have their reports with them. If they are not certain of an answer, just beg the court's indulgence for a minute. I have never known a judge to demand an answer right then and there.
Yeah.
If you ask, can I just have a second, judge? Sure, go right ahead. Yeah. And you look and find the proper answer and give that to the jury.
I think that's key.
Yeah.
That's the key point.
Yep.
And that's something that you and I had spoken briefly before we even started doing the interview here is what you just said. And I'd like you to make that point again because it's very important. Because I think some officers do think maybe, well, the judge is looking at me and all the people in the gallery are looking at me and the jury's looking at me. I got to spout this stuff off. It's not a big deal to give me a minute here. Let me look over my stuff and make sure I give you a proper answer.
Now, that is not to say don't look over your report before you come into the courtroom. Read it, know it. But when you are stuck for, if you know the answer's there somewhere, but you just got to find the documentation for it that you have made beforehand.
Sure.
Then take the time.
Yeah.
Don't get in a rush. Again, judges are there. They want to keep the trial moving,
right,
but not at the expense of not giving the jury the information they need to render a proper decision.
Going back to putting together a case, give us some examples of exactly what you absolutely need as a prosecutor to successfully prosecute a case against what you may not necessarily need or may be less important of an item, either in documentation or physical evidence for a successful prosecution.
Well, you asked about physical evidence. The old line about you get one chance to make a first impression.
Yeah.
You don't get a second chance to make a first impression,
right.
I think. You don't get a second chance to process a crime scene either.
Absolutely.
It's one time and
one
that's
and done.
it. So I'm a big advocate of taking more in than you need. Rather have it and not need it than need it and not have it.
It's a good rule of thumb.
Oh, anytime.
Yeah.
So more is better than less. Let's put it that way.
Sure, and we can hash out the ancillary stuff later.
What law enforcement will give us is the big picture, but we need it as thorough an investigation as possible. Nothing is more frustrating than to get in the middle of trial and realize that the defense is talking about something that we don't know about. So we need a thorough picture of what went on. That's the big thing. My job, I've said that part of what I do as a prosecutor is choreography. Not only do I have to know the legal aspects of getting the evidence in, but I also have to look at who would be the best person to convey the evidence. What order should those people be brought to the witness stand in order for the jury to understand, to be able to build the case in their own minds,
right,
and it not be a complete jumble later on. So that's a large part of it. So having a complete picture, and again, this is something we talked about earlier with documentation.
Yeah.
If I've got all of the documents, if I know what evidence we have, maybe what we don't have but can get later on, then I can put a case together pretty well that will create a picture for the jury that they can see. And ultimately, our goal is to do the right thing, but if we're going to trial, we must figure the right thing is finding this guy guilty.